All right, let's talk about something we deal with all the time, but maybe don't really think about contracts. From a simple handshake deal all the way up to those massive 100-page documents. What's the magic that actually makes a promise legally binding? Well, we're about to find out.
Come on, you've totally done this, right? You're faced with that giant wall of text, that terms and conditions page, and you just click I agree and hope for the best. Or maybe you've made a handshake deal and wondered, hey, would this actually hold up in court? So what is it that gives a promise, whether it's a click or a handshake, the actual force of law?
So today, we're going to peel back the curtain and look at the secret life of a contract. We're going to follow it from the moment it's born, look at its fundamental DNA, uncover some of the dangers lurking in the fine print, and even see what happens when a contract gets, well, sick, and how it all comes to an end.
Okay, so first things first. Every real, valid contract has a few essential ingredients, right? You need an offer, someone has to accept it, and something of value has to be exchanged. But it gets more interesting when you look inside the contract, because not all terms are created equal. They have different levels of importance. Let's get into that DNA.
So check this out. Imagine you're buying a new car. The engine working, that's what we call a condition. It's absolutely essential. It goes to the very root of the deal. If the engine is shot, you can walk away from the whole contract. But what about the radio? That's more like a warranty.
Yeah, it's important, but it's not the main reason you bought the car. If the radio's broken, you can't just cancel the entire deal. Instead, you can sue for damages to get it fixed or replaced. See the difference? It's a really crucial distinction because it totally changes your options when something goes wrong.
All right, now let's talk about the part everyone loves to hate, the fine print. This is where you'll often find these sneaky little things called exemption clauses. And their whole job, really, is to limit or sometimes completely erase a company's legal responsibility if things go south.
So how do these clauses even get into the contract? Well, there are two main ways. The most obvious one, you sign a document that has it. Simple. The other way is by notice. Think about the tiny text on the back of a ticket or a sign hanging on a wall. But here's the kicker. For that notice to count, you have to be made aware of it before or at the very moment you make the deal. If you only see a sign after you've already paid for something, yeah, that's usually too late to count.
And this quote from a classic case way back in 1934 really hammers home just how powerful a signature is. The basic rule the courts follow is incredibly simple. If you put your name on it, you're bound by it. It doesn't matter if you read it or not. It's a pretty powerful and sometimes, a really harsh reality of the law.
But, what if a contract looks perfectly fine on the outside, but there was something fundamentally wrong with how it was created? Well, the law has a name for these problems: vitiating elements. Think of them like a poison that can spoil the entire agreement from the inside out.
First on our list is mistake. And we're not talking about simple buyer's remorse here, like wishing you'd bought the blue one. In legal terms, a mistake is a massive misunderstanding about a core fact of the deal. It's something so fundamental that it can make the entire contract void right from the get-go.
Next up, we've got misrepresentation. This happens when one person makes a false statement of fact that convinces the other person to sign on the dotted line. And notice I said fact. It can't just be an opinion or what we call sales puff, like a salesperson saying, "Oh, this is the best car in the entire world." That doesn't count.
And rounding out our list, we have duress and undue influence. Both of these are about being pressured into a deal you don't really want. Duress is the more obvious one. We're talking direct threats. Undue influence is a bit more subtle. It's when someone abuses a position of power or trust to get you to agree. Either way, the key element of free will is totally gone.
So to see mistake in action, you have to hear the story of the two ships named Peerless. It's a classic. So a buyer and a seller made a deal for a big shipment of cotton coming from Bombay on a ship called the Peerless. Sounds simple, right? Wrong. Turns out there were two ships named Peerless leaving Bombay months apart. And you guessed it, the buyer was thinking of one ship and the seller was thinking of the other. Since their minds never actually met on this super important detail, the court said, nope, there was never a real contract to begin with.
Now, some agreements are just forbidden. They're doomed from the very start. The law will flat out refuse to enforce certain deals either because they're straight up illegal or because they go so against public policy that the courts just want nothing to do with them.
And the list of what counts is actually pretty wild. I mean, you've got the obvious stuff, like a contract to commit a crime. But it also covers things like trading with an enemy during a war, trying to bribe a public official, or any deal that's just a scheme to avoid paying taxes. And if you go back in history, it even included contracts that were seen as promoting sexual immorality.
This old case about the knighthood for sale is a perfect and kind of funny example. So this guy, Mr. Parkinson, gives a huge donation to a charity because they basically promised him they could get him a knighthood in return. Well, the knighthood never came, so he sued to get his donation back. And the court's answer? A big fat no. The whole deal was illegal because it was seen as corrupting public life. The message was clear. You can't just buy a title like that.
And this all comes down to a really old legal rule, which in Latin is extirpe causa non orator actio. But what that really means is simple. You can't base a lawsuit on a shameful act. Basically, if you get involved in an illegal deal, the courts just wash their hands of the whole mess. They're not going to help you enforce it, and you're probably not going to get your money back either.
Okay, so we've seen how contracts are created and how they can go wrong. But what about the end of the line? How do contracts, even the good ones, come to a close? This is what the law calls discharge.
And it really boils down to 4 main ways a contract can end. You've got the happy ending, performance, where everybody just does what they promised. Then there's ending by agreement, where both sides just decide to call it a day. Then you have the messy one, breach, when somebody doesn't hold up their end of the bargain. And finally, there's this really interesting, kind of rare one called frustration. So let's dig into that frustration idea for a second. There's a famous case that explains it perfectly. A guy rented a room with a balcony for one reason and one reason only, to watch King Edward VII's coronation parade. But then the king got sick and the whole parade was called off. The court decided the contract was frustrated. Why? Because the entire point of the deal, the whole reason for renting the room, had completely disappeared. And since it wasn't anyone's fault, the contract was just over. So what happens if someone does break the contract? What can you do about it? Well, these are the remedies. The most common one by far is damages. Basically, the court orders the other person to pay you money to cover your losses. In really rare situations, maybe for something totally unique like a famous painting, a court could order specific performance, which forces them to actually go through with the deal. And lastly, there's rescission, which is like hitting the undo button. It cancels the contract and tries to put everyone back where they started. So there you have it. From its basic DNA to all the ways it can fall apart, that is the life of a contract in a nutshell. And hopefully, the next time you see that little I agree box pop up on your screen, you'll pause for a second. Because now, you know there's this entire world of legal rules, risks, and potential remedies hiding behind that one single click. It really makes you think, doesn't it? What are you really agreeing to?